Good morning, everyone. Bill C-75. How many criminal defense lawyers, people practicing at all in the area of criminal law, do we have in the room? A few. I don't know if everyone's aware of Bill C-75, but all of your criminal law lawyers in the room will be. And this is a situation that there are a number of aspects that we're going to see potentially significant changes in the practice of criminal law. It is a paper that Nathan's spearheaded, and I was there basically in consultation last August. We had very little time to put together our position within our paper, unfortunately, and we had very little time to reach out and have any consultation from you. I can tell you that we started by looking at the Criminal Lawyers Association position, and that we certainly adopted their position, and we stated that in our paper, which you have in your materials. There were numerous changes proposed within the bill that we certainly applaud and support. For instance, the issue of victim fine surcharges. On summary conviction matters, there's a $100 victim fine surcharge that applies, and it's not per information, it's per count with the conviction registered. So if someone pleads to 9 counts, that's $900. On indictable matters, it's $200. It amounts to virtually a user fee within the criminal system, and this is placed on the people who basically do not have the wherewithal to pay a victim fine surcharge. The majority of our clientele are on ODSP, OW, people of a modest ability, and this fine is imposed automatically within 30 days unless you ask for an extension. And you can see how quickly that fine can add up and become an impossible task for payment. Historically, the victim fine surcharge has existed, but the judiciary had the ability to waive it and to take into consideration the circumstances of an individual. Case law has allowed that somewhat at present, for instance, if there's a mental health aspect. And some judges, that's another issue, is there isn't uniformity. There isn't uniformity within local jurisdictions, and there is not uniformity provincially. I can tell you that I was recently in another jurisdiction up in the Kingston area, and I sat there for the morning waiting for my case, and I didn't hear the issue of victim fine surcharges not once. And I asked the local defense counsel present. They said, oh, we just don't deal with those. They don't exist. Where I come from, they're imposed routinely. And so we need to have an ability for the judges to assess when it is appropriate or not appropriate, more likely, to impose. So we certainly would like to see that aspect move forward so that there can be exemptions. Also, another issue is the incorporation of a requirement that always at bail hearings, it's taken into consideration when dealing with Indigenous persons and vulnerable populations, again focusing on mental health issues and looking at a judicial interim release, which would be appropriate for those vulnerable communities within the Corrections Canada system. There's also an amendment to the Youth Criminal Justice Act that is contemplated, and it would see a far greater discretion for matters not even to go into the criminal court system, and for there to be extrajudicial measures to avoid laying criminal charges whatsoever. So a diversion program, if you will, prior to ever hitting the court system. Those are the aspects that we support. In opposition, we raise a serious concern with regard to changes to preliminary inquiries. It is and has been long-standing. I've been practicing 24 years. I'm a criminal defense lawyer, and from the day my feet landed on the ground, I've been told, enjoy your preliminary hearing. They're not going to be around for much longer. 24 years later, we still have them. I have found that preliminary inquiries or hearings are very beneficial in terms of hearing the evidence of the Crown's witnesses in advance of trial. And oftentimes it's very beneficial at a number of levels. One is for resolution, narrowing down issues that may go on to trial and eliminating counts that do not need to move forward. It also becomes an ability, a tool to bargain with the Crown attorney by having that transcript and showing the Crown ahead of time the frailties within their case and trying to get down to the counts to which an individual is actually guilty, and then being able to eliminate the need to go to trial in the Superior Court of Justice. Oftentimes eliminating the need for the public to attend and for a jury to move forward. Another significant area is the Constitution, charter rights, and the ability to hear evidence and create a foundation or a basis upon which you can move forward with your charter issues in advance of trial in the Superior Court of Justice. Without a preliminary hearing, you won't necessarily have that foundation as readily visible, the transparency available to put together your materials and to look at the case law and then to be as persuasive. At least that's what I anticipate and I'm concerned about. And we raised these concerns in our paper. Those are the areas I'm going to deal with, and Nathan's going to deal with the others.
Sure, thank you. Simply put, I'll also just comment, for those of you who do civil law, would you do a trial without a discovery? No. So why are we taking criminal justice, the most serious criminal matters, and saying that there is no discovery process? Same problem. The second issue that we're raising issue with is the challenges, preemptory challenges for jurors. Those are being eliminated as the bill is currently written. Again, in civil law, you get preemptory challenges. Why would criminal law not get some form as well? Why should we not be able to challenge jurors? The only acceptable way would be if we can prove a bias on a person, and that is exceptionally difficult to prove the bias rather than an absence of bias, which would be usually the requirement that we would seek out. The government is worried as a result of certain cases that have come down the line that defense counsel and in large part Crown attorneys as well seek to keep certain people, especially racialized people or Indigenous peoples, off of juries. I can tell you from a defense perspective, I want people who have been treated poorly by the justice system because they make the best jurors for me. The Crown, I'm also a prosecutor, and frankly I want my jurors to be as widely picked as possible. So I think we're reaching very far to deal with a small problem and something that realistically isn't a problem. The final final portion, the allowing of routine evidence to be admitted by affidavit. What is routine evidence in a criminal matter? Very little. But according to these amendments, virtually all police evidence will be able to be admitted by affidavit. We already allow this if it's on consent. What it's now requiring is that a defendant would need to apply to the court to be able to cross-examine on that sort of evidence. Again, consider your civil trials, consider your family trials. Imagine if the other side in our adversarial process could put an affidavit up there and you had to justify why you get to ask questions. Now imagine you're facing a lifetime jail sentence. Imagine you're facing years in jail, being placed on a sex offender registry. Why should you not get the same protections that you get in a civil matter, that you get in a family law matter? And those are the issues that we really identify. There is also a different way to deal with what are called routine or technical breaches, which should move certain matters through the court. But again, it's something where sometimes it's good thought, but the question mark is going to be how it's applied and whether or not any funding actually comes through for these sorts of things. So it's going to be a very interesting sort of time for criminal lawyers over the next couple of months to see where we go with this. I know, we saw a dozen people put up their hands on criminal law, that they practice in criminal law, but this is something that affects all of us, so get your voice heard and make sure the criminal lawyers in your association are engaged in this and are speaking. We all know politicians, we all know people who sit on these committees. Make sure our voice is heard. Thank you.
I may not talk as loud as Nathan, so I might need this. Good morning, I'm Valerie Brown. I'm the family chair. First, I want to congratulate the former family chair, Sonia Jane, on her recent appointment to the family bench in Barrie. Very good appointment, and high praise from Justice Smith, who considered it her favorite swearing-in ceremony, and she's done quite a few. I'm going to speak briefly about some of the areas that are of importance to family law lawyers these days, but I think the area of most importance or most concern to lawyers is one that I can't provide too much of an update today. That's the Law Society consultation regarding non-lawyer licensees practicing family law. I've set out a good deal of the history in the written materials, and it was presented on at last plenary, so I'd like to refer you to that because I know we have a limited amount of time to speak to it, but the long and short is almost a year ago the Law Society accepted a good number of the recommendations of Justice Boncallo in her family law or family legal services review report relating to the promotion of unbundled services and, more controversially, creating a special license for non-lawyer licensees. Justice Boncallo had recommended the Law Society start with paralegals because there is a licensing process already in place. The Law Society is taking it beyond that and looking at all non-lawyer licensees. What's yet to be determined is what the scope of that practice will be and what the credentialing will be, or credentializing, whatever the term is the Law Society is using. I think what came out at the last plenary after Diana Miles spoke was there's a great concern about how this is to be marketed or labeled as well. So what is on the docket is next week the Law Society is having 2 days of workshops, which we'll be participating in to workshop the scope and credentialing, and I think that's an issue that I will raise as well in that context. So given the good presentation that Katie just did on the website, because I don't have an update for you today on that issue, perhaps the website would be a good way to reach out to you after that consultation step has taken place. So I'm sorry, I don't have more to report to you right now. I know that the bar is still resisting this move, but it's happening. So we have to keep our voices heard with respect to the scope and credentialing. Unbundled services, or unbundled family law services pilot project, that's perhaps where I can provide more of an update. In response to the Boncallo report, which again is promoting unbundled services, this is a private bar initiative. This is not the Law Society initiative. They're not involved. I believe that they're going to be speaking later this afternoon about what they're doing. But groups such as the OBA, FOLA, academics, the judiciary, they're involved in this initiative. And it's to close that gap between people that don't qualify for legal aid but can't really afford a lawyer. So it's a three-pronged approach, which is to promote the use of limited scope retainers, also to promote legal coaching, and thirdly, and perhaps this will be the hallmark of it, is summary legal counsel or day of court counsel. This would still be a private retainer between lawyer and client. It's not that they would be getting paid through legal aid, for instance, or some sort of organization like legal aid. It's still a private retainer, but it's making duty counsel, or duty counsel is not the right term, but summary counsel available for the day of court. To qualify to provide that service, it's not a difficult test. 3 years in practice with 30% of your practice being family law or more. You also have to complete the training. Now, as a pilot project, it's being launched in Barrie, so the training in Barrie took place in June. It's only in the past few weeks that the Summary Duty Council has started. I understand that it's being received well, it's being used, but I don't have statistics yet because it is so new. The website, which is to promote the project and to support both self-represented people and lawyers offering unbundled services, will be launching in the new year. The next training is scheduled to take place in Toronto, December 5th. It's being offered by the OBA. You can get some CPD hours and you don't have to pay. So if this is of interest to you, and we would like you to try and promote it amongst your membership, that may be training you want to partake of, but also they're willing to come to you and do training. Now, in the materials, you should have a template letter that you can adapt to your own association and distribute it, and we'd ask that you do that. So now Catherine can report back to Janet, who's on the steering committee, that I've done my job. When we were at Plenary the last time, we spoke about the consultation the Ministry of Justice had regarding upcoming reforms, most importantly to the Divorce Act, that came out after Plenary. The first reading was May 22nd. More recently, last month, was the second reading, and it's been referred to as standing committee at this point. Basically, the hallmarks are a change in language. We're transitioning from the harsh language of custody and access to decision-making authority and parenting plans. And I think for the most part, that's being well received. But victims' rights groups have some concern that it doesn't have the same certainty as custody and access, which might be necessary for police, for instance. So they may be making submissions to the standing committee at this stage. I'm not sure. We'll see. There's an emphasis on alternative dispute resolution and lawyers being required to promote it and use it where appropriate. And I think what I'm most excited about is the presumptions in mobility cases, whereas right now you never know what's going to happen. On the Unified Family Court front, Phase 1 is expected to be completed by May, and that includes 9 new locations and 14 new family judges. The commitment was also to expanding province-wide by 2025, and I think that's where in the next little bit we're going to have to be a bit more active because there is no apparent plan in place to make that happen. Facilities will be an issue, so not sure what the plan is to get the physical locations available, much less the staff and other commitments that go with it. So that, I think, I may have come in time. That's it for family law for now.
My name is John Krawchenko. I'm the Central South Rep and the Governance Committee Chair. Reading through my report, I think I'm going to rejig it a little bit only to provide people with context. You may be aware that there was a governance task force was established in September of 2016 by the Law Society to review the Law Society's governance. They put out a response for call for comment on the 9th of August 2018, and I was fortunate enough to be tasked with the chairmanship of this particular committee to put in our response for FOLA, which we did. Prior to undertaking that role, I had to educate myself a little bit, and this is part of the primer that I wanted to offer to you, if you'll allow me this small indulgence, because I didn't really know this until I got into this particular task. I looked at the, and this again is for background and context only, the function of the Law Society, because they're going out to change their governance model or hoping to do so. I thought, like, what exactly is the function of the Law Society? And it's actually set out in the Law Society Act at section 4.1. There's 2 things that are set out in that section. One is they are there to ensure that lawyers and paralegals meet the standards of learning, professional competence, and professional conduct appropriate for the legal services they provide, and 2, to ensure that these standards apply equally to lawyers and paralegals. At section 4.2, they expand on that, and they set out exactly what they're supposed to do in carrying out its functions and duties, and they have 5 principles that they're to follow. They are this: they have a duty to maintain and advance the cause of justice and the rule of law. 2, a duty to act so as to facilitate access to justice for Ontarians. 3, a duty to protect the public interest. 4, duty to act in a timely, open, efficient manner. And 5, ensuring that standards of learning, professional competence and conduct, and restrictions on who may provide particular legal services be proportionate to the significance of the regulatory objectives sought to be realized. Quite frankly, I understood 1 through 4. Number 5, I'm kind of at a loss at. But anyways, again, this is just simply background for you to understand the context of what the Law Society is there to do. Now I'm going to delve into what they are in the process of doing by way of this governance review. So, again, they asked for comment. Their mandate of this committee was to make recommendations to Convocation to improve the Law Society's corporate governance through greater transparency, inclusiveness, effectiveness, efficiency, and cost effectiveness. And in its call for response, the task force put forward essentially a menu of changes. Now, this can be seen as a sinister thing or a simplification to make our job easier. I'll leave that up to you, but they essentially provided a menu to choose from as far as commenting on. The task force plans to report to convocation by the end of 2018 with recommended changes. Now, again, the Law Society received 14 individual submissions, 12 organizational submissions, 5 of which came from within this room, 4 associations and FOLA. Again, this is simply to put this into perspective about what is happening and how these changes are being driven. In preparing our submissions, FOLA, we sought input from all our associations. I can advise you that I was not overwhelmed by email responses from people. I'll comment on that at the very end. However, from the responses that we received, we then put together our materials, which are in your plenary materials, and they're also on the website for the Law Society. So if you want to look at these individual submissions and the institutional submissions, they are on the website under the governance subheading. Now I'll go through the questions and then the answers that we put in. In summary, they went like this. Should the Law Society reduce elected lawyer benchers? There were variations in positions from outright rejection that we received of a reduction to qualified support of this notion if we maintained an appropriate ratio of lawyers to paralegal representation. Those opposing reduction of numbers of benchers stated that there was no evidence provided to suggest that there was a necessity to even do so. The second question was, are there risks and problems arising from reducing the elected bencher numbers? There was consensus in all our responses that work, creating an agenda, and de facto decision-making would be transferred to an unelected bureaucracy. So if you reduce the number of benchers doing the job, somebody would have to do it, and it would probably end up at somebody's desk in the bureaucracy. Third question, should we continue to have regional benchers? The consensus was that regional representation was essential. A fourth question was whether or not what our position was regarding a regional scheme of election for paralegals. We took no position on that issue. The fifth question was, should the Law Society have the ability to fill board positions, or bencher positions, if you will, by way of an appointment? The consensus, again, in our paper was in opposition to this proposition. As far as their goal, the Law Society's goal of promoting diversity through this form of process of appointments, the consensus again was that this was best accomplished, that is to say diversity was best accomplished by making appointments to committees and work groups and not by circumventing the election process. With respect to the next area, which was terms of office and nomenclature, that was the second part. The first dealt with benchers, the next dealt with terms and naming of things. The consensus was that a latter system of leadership was appropriate to the treasurer's position, with 2 vice presidents and a president versus other options that were put forward. The consensus also was a reduction of bencher terms from the current 4 years to 3 years, and also consensus was a reduction of a maximum term from the current 12 years to 9 years. There was consensus as well in our report that changes to the traditional naming that we have, such as a treasurer to a president and bencher to director, that was appropriate. Other submissions, as I said, can be found on the website, and there were variations throughout. There were, for instance, on the nomenclature, some said that we should hold on to those vestiges of the past because it really didn't make any difference to anybody else other to ourselves, but you can read them and you can see that there were a wide variety of thoughts on it. In conclusion, I wanted to suggest to you this, that given the numbers that we received, the information we received from our membership, and given the numbers of associations that responded, out of all of the associations in Ontario, only 4 responded. I think that this is a perfect opportunity to advertise FOLA's usefulness to the smaller associations. Not every association has the ability to get together a group, put together a working group, put together submissions, and get them out the door in the short period of time that we're given. However, there's nothing stopping you with having a phone call with your constituents, your associations, and sending it to us at FOLA. And then it can be included in a report or in a submission that includes your thoughts and positions. And I urge you to do that in the future as these sorts of things come up, and they do come up quite often. If you can't put them in yourself, then by all means, please use FOLA as that vehicle. So thank you.
Lastly, I'm going to address the issue of legal aid. I have been serving as your chair since just before the May plenary. You may recall, for those of you who were in attendance, that Jane Robertson and I both co-presented at the May plenary. At this point, I have now assumed the role as chair, and Jane is now treasurer, as I think everyone in the room knows. I would appreciate it if, as a group, we could take the time right now to just give a round of applause to Jane for 4 years of excellent, excellent service. Sorry, Jane, but it's well-deserved. It really is. Jane has left some very large shoes for me to fill. I can tell you that I'm still very, very new in this position, and I'm hopeful that I will serve all of you well in it. In order to do so, I need your input, I need your communication, I need your comments, I need to know where the concerns are and where you want to applaud legal aid for programs that they have implemented. There are many changes going on right now at legal aid. There is a complete restructuring which is taking place, as I understand, January 2019, with a number of vice presidents being reassigned or assigned new tasks and titles and roles, as I appreciate it. I can tell you that since the May plenary, I've had an opportunity to meet with David McKillop on 2 occasions. For those of you who don't know, he is one of the vice presidents. He also has on his title Policy and Research and External Relations. Further to my first meeting with him, he invited me to have the opportunity to meet the president, CEO, David Fields, and that was a very good luncheon meeting. And at this point, it's just a matter of getting to know the personalities and getting to know the people and who they are, and having that access, the open door access that they appear to be inviting us to have with them. I can tell you that a third meeting was had with Kathleen Murphy. Her formal title is Director of Communications and Stakeholder Relations. And that meeting took place along with David McKillop, and Katie was with me at that meeting, and the meeting as well with Mr. McKillop and Mr. Fields. There are areas that I personally, as a long-standing criminal defense lawyer and legal aid practitioner, see in terms of billing irritants and those sort of problems, and I'm told that I will be able to assist with certain individuals within legal aid who want to hear from us on such matters. I can also advise that a large part of my role here has been being involved with ASLA and attending a number of teleconferences, but at this point it's still very difficult for me to sort out all of the players when you're hearing voices, and Jane's smiling, when you're hearing voices on the phone and no one's identifying themselves, so you're trying to sort out who's speaking and when and follow the chain of command and who's putting forward which suggestions. So I'm still trying to sort that out, and I really do need your input so that I can participate and have a voice with ASLA. Lastly, I can advise that both Nathan and I, through FOLA on the executive, were approached by Legal Aid, and we were asked if we would become involved with two committees, the one dealing with youth issues and the one with mental health issues. I have accepted the responsibility to become involved with mental health issues, and Nathan with youth. So if you have any concerns or commentary in those particular areas that you want brought back to Legal Aid, I would invite you to approach us at any time over the next few days. Tomorrow, I guess, or reach out to us. We're always available when we're not sitting at plenary, of course. Thank you very much.